Yes, video lecture 9 of the Legal Dimension of Europe. Today we're going to talk about freedom to provide services and freedom of establishment. So this is again one of the key freedoms. We already discussed the free movement of goods, and now we're moving on to the services and establishment. So we see some examples here and of course we already discussed persons as well and citizenship. And here we see some examples of services, for example, the plumber or the hairdresser. And these are clear services. You pay something in return, you get things fixed in your home, or you get your hair done. Something that I never do, of course, but if you still have hair, you go to the hairdresser. So these are examples of services that are being provided. If we talk about establishment, you should think of a Dutch plumber that established himself or herself in, for example, Germany. And this cross-border issue is, of course, very important when we talk about European Union law. It's always about one person in a member state, either a legal person or a natural person, moving to another member state, and there these articles are relevant. Can they provide the services over there? Can they establish themselves in a different country? That's, of course, the key point. So, a very simple outline today. We're going to start with the freedom to establish oneself in a different member state. Then we go into the services. And finally, we say a few words about the recognition of qualifications. This is essentially about diplomas. So if you have a degree, or I should say degree, if you have a degree from one country, can you use that in a different EU country? Because that could be a huge obstacle, of course, if you want to provide a service elsewhere and your degree is not recognized. All right, let's start with establishment. Article 49 until 55 of the TFEU. These articles, they regulate the freedom to establish oneself, so you find all the information there. Starting with Article 49, this is a quotation from the article. Restrictions on the freedom of establishment of nationals of a member state in the territory of another member state. So here we see it. It's always about this move between two countries or more. Shall be prohibited. Again, a very compelling prohibition, so there should not be any restrictions. Such prohibition shall also apply to restrictions on the setting up of agencies, branches, or subsidiaries by nationals of any member state established in the territory of any member state. Freedom of establishment shall include the right to take up and pursue activities as self-employed persons and to set up and manage undertakings in particular companies or firms. So here you see some more specificity. So setting up agencies, branches, subsidiaries. These are, of course, all examples of establishment elsewhere in the European Union. So if I have a little plumbing company here in The Hague and I want to branch out to Belgium, I should be able to set up my agency, my subsidiary rather maybe, in Belgium. And in principle, there should not be any obstacle to that. That's the idea of the free movement, that I can also work in other EU member states without obstructions. We go to some cases now to illustrate how this establishment was carved out. And we start with the Reiners case, which is a classic. As you can see, it's from 1974. And this was a very important case in which, again, non-discrimination, we've seen it before, was established in the field of establishment. You have to imagine that these cases, many of these important cases are from the 60s or 70s, when the European Union was not as free as it is today. And so what we are showing you is how this freedom was carved out, especially by the Court of Justice. So the case was about Mr. Reiners. Mr. Reiners was Dutch, and he studies and lives in Belgium. He studies law there, and then after he graduates, he wants to become a member of the Flemish Bar Association. That is the professional association for lawyers. They exist in all countries. And so if you want to practice in front of a court, you have to register at the Bar Association, and not to be mixed with the idea of a bar when you drink. No, this is a professional lawyers organization. After you register, you're allowed to go to the courts and actually represent clients in court. So he applies to become a member in Belgium at the Flemish Bar Association, but he gets a rejection. And the reasoning is, sorry, you do not have a Belgian passport. Now, of course, Mr. Reiners studied law, so he knew a little bit about the rules of the European community back then. And he said, listen, this seems to be wrong, because how can you have free movement of persons, and how can you freely establish yourself elsewhere in a European Union country if you can be discriminated like this? So he went to court. So Reiner said, this is direct discrimination. I'm being discriminated on the basis of my nationality. I go to the Belgian court, and the Belgian court, remember the procedures that we practiced. The Belgian court asks the question to Luxembourg, to the Court of Justice, a preliminary reference. And the question is this indeed a violation of the freedom to establish oneself? The Court of Justice, back then it had a different name, but anyway, it doesn't matter. The Court of Justice decides that Article 49 on the right of establishment is directly applicable. So remember, directly applicable and has direct effect. All these articles that have been deemed by the court to have direct effect, meaning that they can be invoked in a national court. And it is to be interpreted in the light of non-discrimination. Article 18 TFEU. So, in other words, Reiners is right. You cannot discriminate a person on the basis of his or her nationality. Some exceptions are allowed. You can find them in Article 51, and this is when the job that you want to exercise, or the function rather that you want to exercise, is part of the exercise of official authority. Now, this is not applicable to lawyers according to the Court of Justice of the EU. So in other words, you can also have work in a different country as a lawyer with a different nationality. Now, this is of course a very important case that carves out the space for establishment, because after this judgment it was clear that if you study in a different member state, let's say I go to Italy, I study law at an Italian university, I graduate, I do the Italian bar exam, I register for the bar in Italy, I cannot be denied access to the bar only for not being Italian. If I have studied and I have shown I have the qualifications that I know the Italian law, I should be able to operate as a lawyer. Good. Well, I said we would do some cases, actually only one case, but a very important one. We'll do another case when we discuss the services that we do now. So, the services are regulated in Articles 56 until 62. And the key difference between what we said before about establishment and services is there's an element of durability and continuity when we talk about establishment. Yeah. So basically, when you establish yourself somewhere else in the European Union, there's not an end date in principle. You go there really to work there for a long time, to set up your agency and be active on that market for a long time. When we are in the provide service area, it's always about a short-term activity. Yeah. Now, there's a gray area here, of course, where providing services regularly transitions into establishing yourself somewhere else. So that's always important to keep in mind. But in principle, when we talk about freedom to provide services, we talk about more short-term activities, once in a while, now and then. You go there, provide the service, come back. Or, also important, you receive the service somewhere else. So I go to the hairdresser. Hairdresser is a bad example for me, but I go to the plumber in Germany. I live at the border area, but I want a German plumber. Then I can go there and get my service over there. Yeah, so it's not only about providing services over the border, but also receiving services over the border. Yeah, or whatever, a beauty treatment, you go somewhere else to get the service. Maybe that's a better example for me. Alright, Article 56 lays down the basic rule within the framework of the provisions set out below. That is, of course, in the other paragraphs of the article. Restrictions on freedom to provide services within the Union shall be prohibited in respect of nationals of member states who are established in a member state other than that of the person for whom the services are intended. So you see again, the basic rule, there should not be any restrictions on the freedom to provide and receive services. So what is a service? The service is, maybe it's good to understand that the service area is by far the largest area of the economy in Europe. So it's not a small thing we're talking about here. It's a big chunk of the total economic activity in Europe, in the European Union. And if you want to have a better grip on what a service is, then you can use Article 57 for that. Services shall be considered to be services within the meaning of the treaties where they are normally provided for remuneration. That means that you pay for it. Remuneration is to pay for it. Remember what we discussed about workers. There was also remuneration, salary involved there. So you have to pay for it, remuneration, insofar as they are not governed by the provisions relating to freedom of movement for goods, capital, and persons. So you see, it's basically a rest category. So if you cannot place the activity under either free movement of goods, capital, persons, then you can put them under services. To make it even clearer, there are some examples in the article. So services shall, I thought I switched off my phone, but services shall in particular include activities of an industrial character, activities of a commercial character, and activities of craftsmen, activities of the professions. So these are some specific indications of what these services are. Again, a case. This time the Van Binsbergen case. You see, 1974, again one of these principal establishing cases that we have. So Reiners was the key case for establishment, and Van Binsbergen is the key case for the freedom to provide services. The case. It was about, again, a Dutch national who had a social security conflict with the board of the metal industry. And he went to the Dutch Social Security Court. Yes, so a person from Binsbergen had a conflict with the board of the metal industry. So he worked in the metal industry, obviously. And he was not happy with this conflict, of course, so he went to a lawyer, and that was Mr. Kortman. So he was represented by Mr. Kortman. So Van Binsbergen, Kortman, metal industry. Now Kortman represented Van Binsbergen in the court in the Netherlands. Yeah. But Kortman, of course, lawyers make a lot of money. So Kortman, with all his money, decided to move to Belgium. Because in Belgium you pay less tax. Basically all the rich people, many rich people, Dutch people, they move to Belgium or elsewhere to pay less taxes. So anyway, Kortman moved to Belgium and then received a letter from the Dutch court that he could no longer represent Mr. Van Binsbergen. Because lawyers that are active in Dutch courts represent clients like Van Binsbergen in Dutch courts, they need to reside in the Netherlands. Now, again, you see a very clear problem here, namely that Kortman, who was a lawyer, again, of course, thought, this is a bit strange because this really restricts my free movement, my freedom to provide services in the European Union between two countries, if I cannot reside in Belgium representing clients in the Netherlands. I have all the qualifications, I'm a Dutch lawyer and so on, but only for not living in the Netherlands I can no longer represent my client. This is an obstruction that is not allowed. So he went to court. He said this implies indirect discrimination. It's not discrimination based on my nationality, but it's discrimination based on my residence, so where I live. The Court of Justice decided in this case similarly to Reiners, but mind you, this is not direct discrimination, but indirect discrimination, that Article 56 and 57 indeed have direct effect, and that both indirect and direct discrimination are prohibited under the article. And in this case, or in general, national rules imposing restrictions on the provisions of services, so the service to represent the client also, need to be objectively justified and proportionate. So the court said, in principle, we do not say it's not allowed to have these kind of restrictions that the Dutch court had, but you have to have a very good reason for it, and it needs to be proportional. Remember, the proportionality principle is always there. And then the court continued to said, well, this residence requirement that a lawyer needs to live in the Netherlands, representing clients in the Netherlands, does not meet these conditions. We do not see how this is necessary, justified, and proportionate. So, in other words, Van Binsbergen, or rather Kortman, won this case too, opening up the field for residing in different member states and representing clients in other member states. So these are the two key judgments, Reiners for establishment, Van Binsbergen for services provision, that you need to know and be able to work with. And they had huge impact, of course, on on these fields. Then we make a big leap forward, or according to some people backward, to 2006. 2006 123, that's the number of the directive, which we call the Services Directive. So, explained the von Binsbergen judgment that opened up the field to provide services, but this was just a general, let's say, opening of the field, and we needed much more detailed rules on how to provide services over borders in the European Union. And those rules are laid down in the Services Directive. Yeah? So the Services Directive is the key directive that contains all the important rules on freedom to provide services all over the European Union. Now, this was a highly controversial directive. That's why I've included the picture of Bolkestein Directive, Frankenstein Directive. Back then, the Dutch politician Bolkestein was the commissioner. Under his responsibility, this directive was initiated by the Commission and also concluded. And he was, his name, of course, is easy to joke with, because it's sort of similar to Frankenstein. So of course they made the connection to show that this was a monstrous directive. This was a monster, basically. Why was it so feared? Now, basically, you see it in the first box. It was a controversial directive. The scope was considered too broad. Covered almost all of the services that were not free of charge. So remember, the biggest chunk of the European economy is the services sector. So this huge chunk of services was all sort of covered by this directive. So what people were essentially afraid of, and this is maybe the important point, is that, for example, a plumber in France would get very unfair competition from a plumber from Bulgaria or Romania or other countries that have much cheaper labor available. Yeah. So there was also the fear of the so-called Polish plumber. This is slightly racist maybe, but the idea was that countries that had higher standards in their of salaries, of remuneration I should rather say, that they would be outperformed and outcompeted by new service providers from member states where the remuneration was lower. This is why there was so much protest against this directive. Initially, there was also the so-called principle of origin in the directive, but that was taken out. This was extremely controversial. This meant basically that any service provider from any member state could work under the local conditions of that member state in other member states. So that would really mean that a plumber from, let's say, Bulgaria would work for the salary or the remuneration of Bulgaria in France or Germany or elsewhere. Now, this would have, of course, destroyed the position of the people in those countries, and that's why it was taken out. But it was initially in the directive. Okay, what was the objective, the goal of this directive? To create a genuine internal market for services and establishment. It was basically to create more clarity, to make things more easy, to get this exchange of services and establishment, to make it easier. And some of the key features of it were, for example, that there should be one single point of contact in every member state that would give all the relevant information for service providers to start up their own service provision. There was also simplification of procedures in there. An interesting one was the so-called Lex Silencio Positivo, which sounds like a Harry Potter spell. But basically it means that if one would ask for a permit to work to provide a service in a different member state, for example, I would go from the Netherlands to France, and I would say in France I want to become a hairdresser, and always this hairdresser, it's my obsession, and I would need a permit for that. Then and the French government would not give me one within a certain reasonable period of time after my application, then I would automatically get it. Yeah, so silencio, silence, if the French authorities would stay silent on my application after a reasonable period of time, I would automatically get the permit. And so this is a system to force the member states to comply, to make the service provision easier, and not to establish all kind of hurdles for service providers. Bear in mind that there are still some sectors that have their own specific regulations and directives, such as financial services, healthcare, pharmaceutical services, and so on. Then we go to the last leg of this class, of this video. So we started with establishment, and we distinguished establishment, what it is. We gave you an important case, Reiners. Then we moved on to services provision. We started by explaining what it is. And then I give you an important case, which was von Binsbergen. Then we made the step to the service directive, the very controversial directive. And now we are arriving at the last leg of this class, which is recognition of qualifications. Basically meaning that you have a certain degree and that your degree should be accepted elsewhere. Or what the rules are on this issue. Because, of course, if you want to start up your own service in a different member states and you need a certain degree for that, and you have it but it's not recognized, and it's still not working. How does it work? Well, in order to be able to work, to provide services or establish oneself in a host member state, your qualifications, degrees, have to be accepted. It's very important, otherwise the system doesn't work. So the legal basis for that can be found in Articles 46, 53 and 62 of the TFEU. And there you can find the basic rule that there should be some recognition, and this was then laid down in more detailed ways in Directive 2005/36, 2013/55. That was the amended version. So we see the article here. I'm not going to read it this time for the sake of time, but you can look it up yourselves. So this is the basic rule on recognition of diplomas, or degrees rather. Okay, so there's an obligation for the national authorities to consider training and qualifications of the person that comes in, or the person wants to provide the service or establish him or herself or be active as a worker. And so this comparison needs to take place. If the qualifications in the host member state and or the home member state and the host member states are equal, then the degree, rather the diploma it says here, must be accepted. Where they are not, this must be duly motivated. The decision not to recognize must be open to judicial review. So if you don't get a recognition of your qualifications, then you should have the possibility to go to a court and have it tested. If there's a difference, there are two options. One is you get an adaptation period in which you can adapt to the host member states' rules and regulations and become, or practice rather, you become more able to work there under those conditions, or they have to give you a test where you can show your aptitude. So that's called the aptitude test. If the professional activity requires knowledge of national law as an essential and constant aspect of the professional activity, this also needs to be done. And so the adaptation period or the aptitude test. That's it. Okay, so we're going to practice with this as always in the seminars, and you will get some cases there where you can work with the difference between establishment services and recognition of diplomas or degrees. And I think that's all to say about it. So next week we're going to start with competition law, and that's already the end, moving towards the end of the course. So there are 2 more video lectures to come. Bye bye.